Hi, everyone. Good afternoon. My name is Michelle D'Amico, and I'm the Director of Continuing Education and Public Programs at the NYU SPS Center for Global Affairs, or CGA. I'd like to thank you for joining us today and provide a quick introduction to who we are for those of you who are new to our community. Since its founding, our goal at the Center for Global Affairs has been to prepare global citizens to make a positive impact on the world. We do this through a variety of activities, including our 2 graduate programs, one in global affairs and a recently launched MS in global security, conflict, and cybercrime. We also offer a variety of professional and personal enrichment continuing education courses in the areas of global affairs and fundraising. This includes several professional certificates. And of course, we host free public events such as this that expand upon the critical issues and timely topics that we cover in our classrooms. We'll send out a follow-up message to all attendees, so please feel free to reach out with any questions. We have also reserved some time at the end of today's event for questions from the audience. Please submit your questions via the Q&A tool. And now I'd like to turn this over to Jennifer Trahan, Clinical Professor and Director of the Concentration in International Law and Human Rights here at the CGA, to begin today's event. Jennifer, the virtual floor is all yours.
Thank you, Michelle, and welcome to the audience. It's my great pleasure to introduce Ambassador Christian Wenaweser, who will be delivering our opening address. He is permanent representative of the mission of Liechtenstein to the United Nations. He chaired the negotiations of the Special Working Group on the Crime of Aggression from 2003 until 2009, where the definition of the crime of aggression was concluded. He has also served as president of the Assembly of State Parties of the International Criminal Court, and the permanent mission of Liechtenstein under his leadership recently convened meetings of the Council of Advisors on the application of the Rome Statute to cyber warfare and prepared a seminal report on that topic. And both Professor Hathaway and I had the privilege of serving on that council. Ambassador Wenaweser.
Thank you so much, Jennifer. It's a great pleasure for me to be here and to offer a few opening comments from our perspective. You know, as you have indicated, we have been working on international justice issues for many years, and the topic on the discussion today, in a somewhat sad way, is a culmination of many of the efforts that we have been working on in the past decade and more. So I want to talk about 3 things quickly to you, and then hand over to the panelists. The first is the role of the International Criminal Court in creating accountability for Ukraine. The second is the specifics on the crime of aggression, and the third, a very brief reference to aggression in the cyber sphere in particular, and also other crimes committed in cyber based on the report that you have mentioned. So on the role of the International Criminal Court, we are one of 41 states that have referred this situation to the International Criminal Court. We have done so with the clear understanding that this is, essentially a political statement and a request to the prosecutor to expedite his investigation on Ukraine that was already going on. We have also done so with the very clear understanding that this will not go at the expense of other activities undertaken by the International Criminal Court and by the Office of the Prosecutor in particular. To us, it is extremely important for the work of the ICC and its perception that we avoid any impression that the ICC, which is an international criminal court, has now a unique focus on Ukraine that takes away resources from other investigations. This has translated in our position on financing. So we very strongly favor giving additional resources to the Office of the prosecutor, as we have done in the past. And we hope that this is a seminal moment for us as state parties to come to a better policy on budget issues. We do, of course, see that there is a need for short-term additional financing for OTP, which again we fully support. We do believe the best way of doing this is accessing the contingency fund that has established by the state parties for this purpose. So this is, how we are looking at the ICC activities in this respect. We have, of course, seen the statements from the prosecutor, in particular, also his call for additional funding that he has indicated himself should be across the board for all his activities. So we find ourselves aligned certainly with that statement. We expect the ICC investigation, of course, to be focused on the issue of war crimes, which has been reported on very prominently in the media, with statements from the President of the United States and others that have internally come to a clear determination in this respect. There may at a later stage also be crimes against humanity issues, which of course fall under the jurisdiction of the ICC. And that is, for me, a segue to the second topic, the crime of aggression, which you have indicated in your introduction, Jennifer, is of course a topic that is of particular importance to us, given the role that we have played in developing the law reflected in the Kampala amendments and in the Rome Statute. So the International Criminal Court, of course, does have jurisdiction over this crime. It does have jurisdiction over 4 crimes, and the aggression is one of them, but it is not able to exercise the jurisdiction with respect to the situation in Ukraine for reasons that I don't want to go into detail on, but everybody familiar with the topic knows, of course, that at the Kampala conference, we had very arduous discussions on the jurisdictional regime, and there was an agreement that nationals of non-state parties are exempt from the jurisdiction, and of course the nationals of both Russia and Belarus are nationals of non-state parties. So at this time, and without any further changes to the jurisdictional regime, the ICC is in no position to exercise jurisdiction, very much unfortunately, I have to say, because I think this is the type of situation and challenge for which the states that gathered in Rome in '98 and later on, in fact, have created the International Criminal Court. So of course we are interested in a discussion that goes far beyond this, and in a discussion that can address the question of the jurisdictional regime that we gave to the court in Kampala in 2010, and there is a review of that regime coming up in the next year. That does, of course, not help us much with respect to the challenge we are facing today. And we have said in our public statement now that the General Assembly of the United Nations has overwhelmingly called this an act of aggression on March the 2nd. We do, of course, have a situation in which individual criminal responsibility results under international law, and we do believe that it is really of essential importance that this crime can be prosecuted, and we are interested in finding a way with our like-minded, and hopefully the discussion today will help all of us find the right direction in this respect, because it is very important in our view that we do get this right also for the future. For us, there are a couple of parameters that are clear. The first is that we have an internationally agreed definition of what a crime of aggression is, and that is the definition reflected in the Rome Statute. You have indicated, Jennifer, that I was, of course, chairing the process that led to an agreement on this definition. What I want to emphasize very strongly here is that that was a discussion that was not held among parties to the Rome Statute. It was held among all states. So every state that is a member of the United Nations was invited to participate in these discussions, and states took up that invitation. So the Russian Federation, for example, had a delegation at all these meetings, as did China and others. The US came late into the game, but they were certainly also part of the process, and very strongly so in Kampala. And that is a very, very important point, because it's an internationally, and in a way, universally agreed definition. So it's not owned by the 43 states that have ratified the Kampala Amendment, but really by the international community as a whole. So for us, it goes without saying that this definition should be the basis of any criminal proceedings. The second is we do believe there are, good precedents we can look at and draw from in order to make sure that we have something that has the legitimacy of the international community as a whole, which in our mind can only mean that it is a process that has to go through the United Nations, and given where we are, certainly through its General Assembly. So that is the second parameter that is for us very clear. We have a couple of models from the past, templates that can be used, in particular the template used with respect to Sierra Leone. Some of the details obviously would have to be changed, but we do believe that this is the way to go. And the third parameter for us is that, of course, we need to do this together with our colleagues from Ukraine. Ukraine has referred its situation to the International Criminal Court, and they also have in their National Penal Code a provision on the crime of aggression that, of course, could be combined with the international definition. But the Sierra Leone model would be leading the way here as well. So we have to do this very strongly in partnership with our Ukrainian colleagues, and we are in touch with them as are others. Finally, and I'll be very brief on this, because I know other people in the panel will certainly talk about this in much detail, and I very much look forward to their presentations. We had, long before this, put together a council of advisors that looked at the question of how the Rome Statute, of whether and how the Rome Statute does apply to acts that are committed in cyberspace. That we put together a council of advisors that met here in the conference room where I'm sitting now alone with Ona, who's in the call, with you, Jennifer, and we released the report that we will be making available in the course of this conversation, happily in the chat. Without going into any other detail, the key and important finding is that the Rome Statute does apply to acts committed in cyber, and it does so without any amendments necessary to the Rome Statute. So as we speak now, the prosecutor is in a position to apply the law in the Rome Statute to acts that are committed in cyberspace, which of course has been a very lively and active discussion with respect to the aggression against and the war in Ukraine. And I look forward to hearing more on this from our panelists, and in particular those who have been parts of our council of advisors. Thank you so much for putting this together, Jennifer, and I look forward to the rest of the conversation.
Thank you so much, Ambassador Wenaweser, for those very significant and very powerful remarks. So our audience is not necessarily those well steeped in international law, so I will give a few framing remarks about accountability and then introduce our panelists. So the audience has probably all seen horrific images of the destruction in Ukraine and loss of life. And you know, when one apartment building is hit, one thinks, well, that could have been an error. And then when one sees such systematic destruction, it seems so clear that there is a deliberate campaign. Of course, all of this will need to be investigated up to criminal law standards. One is simply incredulous at the bombing of a theater when the world's children were written on both sides of it. And we're also horrified by the invasion itself. For those not steeped in international law, when you have one country invading its neighbor, as we have had, this is use of force contrary to the UN Charter. It is an act of aggression. And this means that political or military leaders who initiated the invasion have committed the crime of aggression, and we'll discuss where this could be prosecuted. I think all of this sets up tremendous demand for accountability, and the international community has started with a strong response. There's been denunciation of the Russian Federation's act of aggression by a resolution that passed 141 with only 5 opposed. Ambassador Wenaweser referred to the referral of 41 states of the situation in Ukraine. And this is really quite unprecedented. In the past, we've had a referral of 1 country. At most, 5 countries have made a collective referral. And states parties are coming forward with additional voluntary contributions, although as mentioned, there are some complications in terms of it's really better to support the entire budget of the court, and there's some problematic optics of, you know, we want this money to be used only for Ukraine, even though we do want money for Ukraine. But Ambassador Wenaweser has already laid out some of the concerns. We even have seen the US government making welcoming statements suggesting towards accountability and potentially both the International Criminal Court, which comes as quite a reversal from not so recently under the Trump administration, sanctions against the prosecutor and high-level staff in terms of asset freeze and travel bans. Civil society is mobilizing in taking statements and preserving evidence. The Human Rights Council has created a commission of inquiry to investigate human rights violations, crimes, and the commissioners have recently been named. Amazingly, despite being under bombardment, Ukraine was able to go to the International Court of Justice and has already procured a provisional measures ruling from the court. Russia had used as a pretext that genocide was occurring in Donetsk and Luhansk as a pretext for its invasion. And the court said, no, indeed, there is no genocide in Donetsk and Luhansk. This cannot be used as a claim for Russia's intervention and ordering Russia to withdraw its forces. And national jurisdictions in approximately 8 countries have commenced investigations at the domestic level into either war crimes, crime of aggression, or other laws under national state law. And there are positive suggestions being made. How could this gap that we see be fulfilled in terms of an aggression-specific tribunal? And Ambassador Wenaweser, I think, laid out certain of the absolute required preconditions. So this is just to frame where we are. And I think we turn to our panelists in terms of where do we go from here, what impediments exist. And with this, I'll welcome the panelists to turn their cameras back on and rejoin. And I am pleased to announce Ambassador David Sheffer joining us. David held the first post of ambassador at large for war crimes issues during the Clinton administration. He led the negotiations for the US at Rome and participated in the creation of the Yugoslav Rwanda Tribunal, Special Court for Sierra Leone, and Cambodia Tribunal. He is now International Franke Professor at Leuven in Belgium and Senior Fellow at the Council on Foreign Relations. We have Professor Lindsay Friedman. She's Director of Law and Policy for the Tech and Human Rights Program at the UC Berkeley Human Rights Center. Professor Freeman is an international human rights lawyer with experience working at the International Criminal Court and Cambodia Tribunal. Professor Una Hathaway is the Gerard C. and Bernice Latrobe Smith Professor of International Law at Yale Law School, Professor of International Law and Area Studies at Yale University Macmillan Center, Professor of Yale University Department of Political Science, Director of the Yale Law School Center for Global Legal Challenges, and Counselor to the Dean at Yale Law School. And Professor Adel Haq is Professor of Law and Judge John O. Newman Scholar at Rutgers Law School. He writes on the law and ethics of armed conflict, the philosophy of international law. His first book, Law and Morality at War, was published by Oxford University Press in 2017. So I'll ask, we'll have approximately 8 minutes for our first round of questions, and I'm going to start with Professor Haq. Professor, can you discuss which war crimes appear to be occurring in Ukraine, the potential for or impediments to war crimes prosecutions, and the contributions of civil society documentation efforts?
Sure. Thank you. So as Jennifer mentioned, Russian forces appear to be committing war crimes in Ukraine on a large scale, apparently as part of a plan or policy. These include, but unfortunately are not limited to, intentionally directing attacks at civilians and civilian objects, including undefended dwellings, cultural objects, and hospitals. Intentionally launching attacks likely to cause excessive, disproportionate harm to civilians, civilian objects, and notably the natural environment. Intentionally using starvation of civilians as a method of warfare, willful killing, torture, and rape, deportation of Ukrainian civilians to Russia, and taking hostages, including Ukrainian mayors. Individual criminal responsibility for these apparent war crimes extends beyond those who commit them, to those who order their commission, and to those military commanders who know or should know that such crimes will be committed and fail to take necessary and reasonable measures to prevent their commission. In principle, criminal responsibility extends all the way up the chain of command to the Supreme Commander-in-Chief of the Armed Forces of the Russian Federation, Vladimir Putin. While the International Criminal Court has jurisdiction over crimes committed in Ukraine, that jurisdiction extends to criminals who never leave Russia or Belarus, as the case may be. Under general principles of law, a crime is committed both where it begins and where it ends, where any of its elements occur. Similarly, a crime is ordered both where the order is given and where it is received and carried out. And a military commander is responsible for failing to prevent a foreseeable crime, both where they should have taken preventive measures and where those measures would have and should have had their preventive effect. For more on that, I highly recommend a recent essay on the Usual Talk blog, both because it's excellent and because it was written by a Russian international lawyer writing from Russia and writing anonymously to protect themselves and their loved ones. It's a notable example of a person of principle doing what they can, however small, to hold their own leaders accountable for these terrible crimes. I'll put that in the chat later. We don't yet know the full consequences of these apparent war crimes. We know Russian forces have killed over 1,000 civilians, injured at least 2,000, including at least 100 children, and destroyed thousands of homes, businesses, and schools. We know Russian forces have attacked or damaged at least 82 medical facilities, including hospitals, ambulances, and warehouses. The full toll is much higher, especially in cities under siege like Mariupol, where Russian forces have tried to cut civilians off from communication with the outside world. I'll note that not all suffering inflicted on civilians in war necessarily results from a war crime, but I'll also note that Russia incurs state responsibility and owes compensation for each and every death, injury, and dispossession it inflicts in furtherance of its war of aggression. In contrast, there's very little evidence that Ukrainian forces are committing war crimes, let alone on a large scale. We have recently seen a video circulating on social media purporting to show Ukrainian soldiers and militia abusing Russian prisoners, including shooting some in the legs, which would of course constitute a war crime. Ukrainian officials have promised to investigate the incident and prosecute those responsible, as they should. The potential for future prosecutions is quite strong. First, Ukraine's own legal system is still functioning at a high level. Ukraine's prosecutor general says they are actively investigating over 200 suspects for over 2,000 war crimes. They have custody of at least 550 Russian prisoners of war, some of whom may voluntarily provide information on war crimes committed or ordered by others. Ukraine recently formed a legal task force on accountability, featuring some of the world's leading international lawyers, and welcomes Sir Howard Morrison as an independent advisor. Second, Ukraine will have lots of help. 10 other countries have opened their own investigations into war crimes by Russian forces. And every country in the world is not only entitled, but obligated to search for and prosecute or extradite suspected war criminals with some qualifications, and most have adopted national legislation to that effect. The United Nations Human Rights Council has created a commission of inquiry, and of course, the prosecutor of the International Criminal Court has opened an investigation as well. Hopefully, these entities will coordinate their efforts and share information and expertise. And finally, as Jennifer mentioned, we've seen an unprecedented effort to document possible war crimes in close to real time, cross-referencing video footage, audio recordings, and satellite imagery to geolocate and verify events as they happen, or at least within hours or days. We'll know more about who did what, where, and when than in any previous armed conflict. And for more on those issues, I highly recommend a recent essay by Justin Hendricks on the Just Security blog, and I'll put that in the chat soon as well. The main practical obstacles for prosecution will be first getting custody over suspects, particularly high-ranking commanders who stay in Russia or Belarus or avoid capture on the battlefield. And second, getting testimony from Russian soldiers about who made decisions, who gave orders, who knew or should have known that war crimes were underway, but failed as responsible military commanders to prevent them. These obstacles are real and they are substantial, but they are not insuperable. Most defendants in international criminal trials seem untouchable until they aren't. With time and relentless effort, those responsible for war crimes in Ukraine can be held accountable as they must. And with that, I'll turn things over to the next speaker.
Great, thank you so much for that. Just so the audience isn't confused, because he said, normally when a crime occurs in the jurisdiction of a state, the ICC would have jurisdiction. And unfortunately, this is not true for the crime of aggression. It is true for war crimes, and we'll talk about how that came to be. And that is the normal jurisdictional rule, and that is normally what you would expect. Professor Lindsay Freeman, I'm happy to turn to you next. So let's transition to the area of cyber warfare. I put in the chat the report on cyber warfare and ICC Rome Statute crimes that has been referenced before. So there are cyber attacks going on currently in Ukraine, but this is kind of the end of a long series. We had cyber attacks in 2014 against Ukrainian elections, 2015 and 2016, the power grid was taken off. We have the 2017 Not Petty attack, and this spring a whole series of cyber attacks. Can you talk about cyber attacks in Ukraine? Can these be charged as war crimes? And I understand you are working on a submission to the International Criminal Court to this effect. So if you could tell us a little bit about that, that would be terrific. Thank you.
Thank you so much, and thank you for having me here on this fantastic panel. I'm happy to discuss that. So as you said, for the last year, actually, we have been working on a case and investigating the potential of charging cyber attacks that have taken place in Ukraine as war crimes under the Rome Statute. So we started this not anticipating what is happening today, looking at it very much in the context of the armed conflict that began in 2014. So one of the real points of issue when talking about cyber attacks of war crimes is the attack threshold and where that is met. And certainly there's a fair amount of controversy if you don't have an actual armed conflict going on. And, you know, the question of whether cyber means alone could constitute an armed conflict is sort of a more challenging question. So what was interesting about Ukraine was really looking at the nexus to the armed conflict that was already happening, which felt if we were to go to court on this, litigate this issue, that would be, if we could prove that nexus, that would be sort of a more viable case to actually see this through. So we started looking through, well, the law on this, some of the facts and evidence, but also sort of the Russian military doctrine and their cyber structure within their military. And you can see from just reading their own documents and how things have been set up really with reforms starting in 2014, that the cyber and information domains are very much domains of warfare and some of the most important domains they see within warfare. So this hybrid military strategy that has been carried out in Ukraine, where there's a combination of kinetic and non-kinetic military attacks, is very well documented by the Russian government and Russian military itself. And that was another thing in sort of incident selection. We looked at, all the attacks that you mentioned, several others of different levels of reporting. And we looked for attacks where the attribution was very strong and that the attribution was directly to military actors, because the Russian government does use cyber proxies, Cyber Berkut, some pro-Russian hacker groups or criminal groups or the private sector. But we really focused on the ones that were attributable to units within the GRU, and some which are very well documented and where the attribution is very, very strong. And we've already seen some of that in some US cases. And the other thing was looking at purely civilian targets, which wasn't hard because a lot of these do target civilian infrastructure with no military objective. At the same time, though, when you tell the story of looking at the armed conflict with Crimea, the occupation of Crimea, what's happening in Eastern Ukraine, and sort of the land battle, the air battle, and the cyber battle, and the information warfare space, you see how linked they really are, and that there is this communication. They're very much out to achieve the same objectives, same perpetrators against, same victims. So drawing that nexus, I think, is actually quite strong in the case of Ukraine, even before what's been unfolding over the last month or two. Now, with what has happened more recently, I think that just strengthens the case tenfold, because you really see what happened in 2014 as this continuum as one phase of a long-planned military operation that certainly is targeted as the country as a whole and not limited in the view of the perpetrator to specific geographical areas. So they have seen the whole of Ukraine as their battlefield, and that I think will be even stronger to make that connection with what is happening now. One other thing I'll note, and I'm happy to answer questions or talk a bit more about that, the information warfare space is really unique in this conflict as well. And how that is playing out, I think, is something, and to a level we haven't seen before, which is going to make investigating these cases, whether it's cyber war crimes or other types of war crimes, incredibly challenging. So at the Berkeley Human Rights Center in December 2020, we published the Berkeley Protocol on Digital Open Source Investigations, along with the UN Office of the High Commissioner for Human Rights, to put out a set of international standards for how you identify, collect, preserve, verify, and analyze digital open source information. And so that's one that's quite significant here, especially on verification, because right now there's a huge volume of information coming out telling different stories, and it's very hard to get an accurate read on what's going on. We've been focused on the cyber realm, and even in that, you look at the allegations of attacks. Some people see a huge cyber warfare going on. Some people are questioning why hasn't the big cyber attack happened yet, and having attribution to a lot of different groups and confusion around that. And similar things are happening with on the ground. So digital evidence can be incredibly helpful in these cases, but there's also going to be huge hurdles. So some of what we've been doing is working with some of those accountability mechanisms that were mentioned, and Ukrainian groups to sort of implement the protocol and make sure across all of those different avenues that there is this consistency in approach and that information is forensically preserved so that it can be used in court, that the tech companies are aware of this issue and don't destroy evidence, but also have backups preserved as well. And then making sure good verification procedures are in place, so that at the end of the day, we are able to establish what really happened and what didn't. That I'll leave it there. Thank you.
Great, thank you so much for that, Lindsay. That's absolutely fascinating, and what a terrific submission and to the prosecutor's office. Ambassador Scheffer, let me turn to you. So on TV, we see these, horrific images of large-scale destruction. And then I think of the International Criminal Court, and we've all seen it prosecute about 3 to 5 individuals in each situation country. So there may be a big mismatch between what the public thinks could be achieved and what victims' demands for justice are, and ICC capabilities. How will this play out? Will there be a role for domestic jurisdictions? And particularly, if I can ask you about this funding situation, there's been this, as Ambassador Wenaweser mentioned, outpouring of support, yet some of it appears to be earmarked, and many countries are making statements that they're not earmarking their funding. This is a general contribution, which is extremely important. But also in the news, you sometimes see countries, oh, this money is for Ukraine. And then I think raises some optics problems and concerns about whether those countries then expect some kind of outsized influence with the ICC. So if you could address both kind of the capacity issue and then this funding question, that would be great. Thank you.
Thanks very much, Jennifer. And I'm so happy to be with all of my distinguished colleagues on this panel. And I thought that Ambassador Wenaweser made a tremendously informative and helpful opening statement. I think in answer to those particular questions, we need to be careful in recognizing what is happening right now with respect to accountability and Ukraine. I don't think there's any precedent for the degree of intensity that is being applied towards investigation of atrocity crimes within the first month of a major armed conflict of this character. The closest analogy that I could come up with would be Kosovo in 1999, when I was in the US government, and we took initiative very, very quickly to gather as much information as possible, make it available publicly as possible, and bring it together as quickly as possible and professionally as possible, ultimately to provide that evidence to the Yugoslav tribunal. But that effort, which was also joined by other governments, is of very small character compared to what we're witnessing with Ukraine. And I think we need to tread as carefully as possible now. I mean, just within the last couple of weeks, there have been new organizational efforts to launch investigations in Ukraine. We know that, of course, the ICC has jurisdiction. The prosecutor made it quite well known that he was prepared to dive in quickly. 41 states stepped forward to refer the matter to him, and he is off and running. But he doesn't have a sufficient staff to really be racing down the track yet. He's called for secondments from governments of investigative expertise to help build his team on Ukraine. And for those in the audience, I mean, if it's a secondment, then of course the government is covering the cost of the salary and perhaps also of living expenses of the individual who is being seconded. So what the prosecutor was doing was asking for essentially a sort of a budget neutral ramp up in his office in order to deal with Ukraine. That will be interesting to watch play out. It will be fraught with political tension because he could have just as easily asked for a ramp up of secondments on many other situations that are currently before the court. The other thing that I think will be experienced when you get secondments together of that character is that we've now had 30 years of investigative experience in the war crimes tribunals. There is a huge community, a large community of very skilled people out there, investigators, prosecutors, those involved on the defense side, administrative side, victims side. If I may be just sort of frank, it's not a criticism, but these people are very highly talented and driven, and a lot of them are fairly senior rank now after 30 years. So it's going to be a challenge, I think, to, shall we say, control the ego train, because a lot of these people are going to want to do it their way. And it's going to require some very strong leadership to direct them in a coordinated way towards the targets that they need to be professionally investigating and taking guidance and, in fact, orders from other individuals, even if those individuals are not necessarily senior to them in experience. We experience this in organizations of all character around the world, but I'm just saying that not everything is going to be nice and kind. I think there's going to be a lot of tension among investigators who think that their approach is going to be the better approach. The other thing which I point to in that respect, and I'll get to your funding point in a minute, Jennifer, which is this is unprecedented. I mean, there's the UN Human Rights Council, there's OSCE, there is a new group that was just announced by the British government working with the Prosecutor General in Ukraine and led up by Baroness Kennedy and Amal Clooney just a few days ago. And there are other civil society groups, there are human rights organizations, all of them are descending on Ukraine and on the refugee populations for the purpose of collecting evidence. I'm not aware of any effort to literally coordinate among all of these groups. And I do wonder whether it might be important at some point to do so. The United States government is involved as well. I mean, disclaimer, I happen to be part of a State Department grant team that has jurisdiction over Ukraine and, interestingly enough, South Sudan, that is very involved in this now. And yet the issue is everyone coordinating coherently with the Prosecutor General in Ukraine or not? I think she is very gracious in wanting to bring as much to bear as possible on the investigations, particularly during the armed conflict itself. When evidence is being generated every single day, how do you do that on a daily basis, every single day? And yet I'm not sure there's a lot of coordination among all of these different groups that are descending upon Ukraine to make sure, frankly, that refugees who might be very important witnesses ultimately in trials are not being interviewed 4, 5, 6, 7 times. In other words, there needs to be coordination that refugees are not taken advantage of like that. They are victims, and we need to be extremely sensitive to how they are being interviewed, what the protocols are for that whole interview process. I mean, I can just remember in Kosovo, you know, we had an interview center set up at Fort Dixon, New Jersey for Kosovar Albanian refugees, and we put them through a very strict protocol of interviews. so that we were not overstepping in frankly, our privilege to interview them for purposes of ultimately providing that evidence to the Yugoslav tribunal. So I think that's an important point as well. Finally, I'll finish up on funding. Having a fair amount of experience on this, including with the Cambodia tribunal in a very intensive way, there are governments that do want to earmark. It's politically attractive internally, and they want to make a point with their earmark. That's a problem. It's a problem for the financial stability of the organization. In this case, let's say it's the ICC. And it's a problem optically, and it can create enormous tensions. So of course you do want to see funds come in. If they're coming in voluntarily, then they should not be earmarked. And in that way, of course, it will be a very key responsibility of those in the ICC to distribute those funds so that there's, shall we say, sort of a kind of a relative equity among the various situations that are under investigation. My guess is that a lot of governments will say, no, 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 this is voluntary confirmation for Ukraine investigations, period. That would obviously be an earmark. And that's going to be very, very difficult to manage in the political relationships with the Assembly of States parties. So I would expect that you might see at the next meeting of the Assembly of States parties, and maybe they should convene an emergency meeting, whereby they talk about the whole budget issue and how to perhaps get the state party consent to an increase of the budget for a particular purpose, so that you get buy-in by those governments that are more concerned about other situations that are under scrutiny, with so much being afforded to Ukraine. I would conclude by saying that I do want to sort of alert you. I imminently have a report coming out through the U.S. Memorial Holocaust Museum, in which I present proposals for funding initiatives for victims of atrocity crimes. And that includes how to better finance certain accountability exercises like the ICC. And so there will be a lot of ideas in that report, you know, sort of for the long-term better financial health of both the courts themselves, as well as how in the world do we pay for the enormous costs being incurred by the victims themselves and by their societies. Ukraine is Exhibit A. It certainly highlights the problem ahead of us. And it's not going to be covered just by reparations or something like that. It's going to require a very, very innovative approach.
Great, David. Thank you so much for those remarks. Turning to Professor One Hathaway. So we have discussed that the General Assembly has issued a clear resolution that there's been an act of aggression, and in that event, one clearly does have a crime of aggression, but as already mentioned, the International Criminal Court does not have jurisdiction. It is a separate jurisdictional regime than you have for genocide, war crimes, crimes against humanity. And in 2010, when the nationals of non-states parties were carved out of the aggression regime, this has now ended up carving out Russian nationals, crimes committed on Russian territory, or nationals of Belarus, or crimes committed on their territory. So we don't have jurisdiction. So you get a three-part question. How can this gap be remedied going forward? I am part of a group called the Global Institute for the Prevention of Aggression, and we, for instance, have called for state parties to reopen the crime of aggression negotiations and go back to the negotiating table and see if we can remedy the situation of a very fairly small regime of jurisdiction. In your view, are cyber attacks part of the crime of aggression? And there have been these proposals for different tribunals, from kind of a Nuremberg style model proposed by UK academics and UK officials to a multilateral approach, going through the General Assembly and the Ukraine and the UN in agreeing on creating a tribunal using well-established precedent. I wonder if you could weigh in on that debate. Thank you.
Thank you so much. And it's a pleasure to be here. So let me take the question of kind of how do we address the fact that we have a situation where it's quite clear that there very much appears to have been a crime of aggression. There's a clear violation of Article 2.4 of the UN Charter. It's a manifest violation. The General Assembly has called it out as an act of aggression. The claims that Putin made that it was justified by what he claimed to be genocide happening in the eastern part of Ukraine was quite decisively rejected by the International Court of Justice in a sort of unprecedentedly fast set of proceedings where they had preliminary hearing and issued a judgment that there was no justification for Russian aggression in Ukraine based on any claims of genocide, because there was no justification for that. So there seems to be clear violation. This is kind of perhaps one of the clearest cases of a manifest violation of the UN Charter that we've had in many years. And yet we have this awkward situation where although the other crimes in the Rome Statute can be investigated by the International Criminal Court and prosecuted by the court because Ukraine has given jurisdiction over them, because of the unique jurisdictional characteristics of the crime of aggression, that does not carry over to the crime of aggression. So what do we do about that? There have been two main proposals, aside from what you just mentioned, Jennifer, of sort of revisiting the Rome Statute jurisdictional sort of scope and reconsidering whether there should be this restriction so that a state that would otherwise fall within the jurisdiction of the court might be excluded, as is the case here, because the crime of aggression can't be prosecuted against a state that's not party to the statute. But the other two main proposals that had been made is first, a kind of Nuremberg style tribunal. So the United Kingdom prominently kind of came out early on, about a week after the invasion. Former Prime Minister Gordon Brown and a long list of others endorsed the idea of a special tribunal for the punishment of the crime of aggression modeled on the Nuremberg Tribunal, and that has won many supporters. But it has been criticized because this would really be kind of a standalone tribunal. There's kind of concerns about selective justice that, at least as initially proposed, didn't seem to be sort of structured around any kind of international organization. And so a second proposal that has been put forward and I think is gaining steam is a proposal for a hybrid tribunal under the auspices of Ukraine and the UN General Assembly. And this tribunal would really build on the fact that we have an almost unprecedented situation where the General Assembly, 141-5, as you mentioned at the outset, voted to condemn Russia in an unusual use of the Uniting for Peace resolution, which has been largely dormant for quite some time. And build on that kind of almost unanimity among the General Assembly and the interest of Ukraine in moving forward. So Ukraine has made it clear early on after the invasion, endorsed the idea of a tribunal. And so if Ukraine consents to this tribunal and works together with the UN General Assembly to establish it, that would seem to sort of establish it on the kind of firmer international legal ground, kind of under the auspices of the General Assembly. Ambassador Wenaweser, in his opening remarks, sort of mentioned many reasons why this might be the preferable approach to a Nuremberg tribunal style, because it does allow all states that are party to the General Assembly to play some role, as opposed to kind of a small club of states setting up an independent tribunal that might create some precedents that might not be good in the longer term. And you yourself, Jennifer, as I'm sure I don't need to tell you, but others may be interested to know, have written about this in Just Security. And I hope that one of the staff can put that great piece in the chat so that everybody can read it. So those are the kind of two main proposals. And I think the second one, there's lots of reasons to think that the second idea of a coordinated tribunal between Ukraine and the General Assembly, sort of a special tribunal, but set up under the auspices of the General Assembly, may be the more fruitful way forward in terms of establishing a kind of long-term precedent as well. And there have been other instances where the UN, working with states, has set up tribunals, the Sierra Leone tribunal that Ambassador Wenaweser mentioned at the opening. There's also been efforts in the extraordinary chambers in the courts of Cambodia, also provide some precedent, and the international impartial and independent mechanism that was set up to investigate war crimes in Syria also create some evidence that the General Assembly and the UN in general has moved forward to try and to fill some of these gaps that exist in jurisdiction over war crimes, and in this case, a crime of aggression. So to your question of could cyber fall within the scope of the crime of aggression? The report that that was put up in the, I think it was in the Q&A, but maybe it'll also be put up in the chat that you and I contributed to, lays out, examines the way in which the Rome Statute might apply to cyber events. And in that, we struggled with and found, that the crime of aggression can apply to cyber. But the harder question is when you're dealing with standalone cyber events, because with standalone cyber events, whether you're not part of a broader armed conflict, the threshold, the requirement of manifest violation of the UN Charter, which is required under the Rome Statute definition of a crime of aggression, is quite difficult to meet. There have been very few standalone cyber events that are considered to be sufficient to meet the Article 2.4 threshold itself, much less a manifest violation. But here we don't have that difficulty. Here we have a much simpler case in a sense. Here we have cyber operations that are taking place in the context of a clear act of aggression. And whether that could be part of the crime of aggression, I think clearly the answer is yes. The trick will be, and this is something that Lindsay was mentioning in the context of war crimes, but this is true of the crime of aggression as well. The trick is making clear the nexus between the cyber attacks and the crime of aggression. So it's not merely that they're sort of coincidentally happening at the same time, but that it's part and parcel of the acts of aggression, that they're attacking Ukrainian government or Ukrainian forces or civilians as part of the overall war of aggression. And I think that that's the only evidentiary challenge. But if one can establish that, then clearly it could be part of the overall case for a crime of aggression, and anyone who's involved in the planning or carrying out of cyber attacks could potentially be subject to jurisdiction in a tribunal that has jurisdiction over the crime of aggression. So I'll leave it there so we have some time for questions.
Great, thank you so much, Ona. So I now want to go back for a quick second round to each of the panelists, and I'll also invite Ambassador Wenaweser to come back. If you want to just take about 3 or so minutes to reflect on anything any of the others have said, or to add a few additional thoughts, we'll just have a very quick second round for everyone going in the same order. Ambassador Wenaweser. Are you there?
Yes, I'm here. I'm trying to be on video as well. Yeah, no, I've been here all the time, and I've been listening. I don't actually have that much to ask because because I do believe we've had both an excellent and I think a very strongly like-minded conversation on this. So I very much look forward to the Q&A. And I just really want to thank those who have elaborated on the specific aspects, and I'll be very happy to take questions on this. Thanks, Jennifer.
Great, thank you. So then I'll stick with the same order. Adil, would you like to comment or add, etc.?
Sure, I'll just put in my bid for another approach to the issue of aggression. So Shane Darcy and I are fans of amending the Rome Statute to permit the General Assembly, acting under the Uniting for Peace framework, to refer aggression cases to the ICC. It is, I think, a principled response to the problem. It creates a standing mechanism that can be used for Russia today, but China or the United States tomorrow. It avoids charges of selectivity. It's also pragmatic because the ICC is up and running. The upfront costs have been paid. We have an institutional mechanism in place. Jennifer has pointed out in her excellent post, it will take time to amend the statute. The amendments could be, our proposed amendments could be undermined both by states parties like the United Kingdom or outsiders like the United States. So it's not guaranteed, but I think that if there is a viable path for a principled response to aggression, I think it should be pursued. And I don't think we should give up that struggle without a fight. So I'll just put in my vote for that approach.
Adil, I'm going to abuse moderator's privilege and just ask a follow-up there. So given that the General Assembly only has power under the UN Charter to make recommendations, it could recommend a referral, but how do you see it that it has power to create a referral, which, and with a referral, it's basically increasing the jurisdiction and it's potentially getting rid of immunities. So it's quite a significant thing that would be achieved. And it's not that I'm against the concept, but it's simply a question in terms of, you know, Security Council has Chapter 7 power, can create whole tribunals. And so what is your thinking on this?
Sure. So first, there's a distinction between kind of the four corners of the Rome Statute and a question under general international law. Under the Rome Statute, all the Security Council is doing is triggering the court's jurisdiction. Now, there's a legal theory under general international law that what the Security Council is really doing is creating jurisdiction, right? Conferring jurisdiction onto the court. So the General Assembly can perform the first function. It can trigger the jurisdiction of the court. It raises this question under general international law: can the General Assembly give the court, create jurisdiction for the court? The answer doesn't have to be yes for two reasons. So first, if you think there is universal jurisdiction over the crime of aggression, then that jurisdiction could be delegated to the court by the state's parties, and all the General Assembly would be doing is creating a procedural mechanism to trigger the exercise of that jurisdiction that the court already has delegated to it by its state's parties. The second thing, the second way you could deal with this problem is if the victim state, in this case Ukraine, accepts the jurisdiction of the court, which it has, this objection goes away because the victim state would be delegating its territorial jurisdiction to the court. So the objection from general international law falls away. More to say, but I'll
yeah. So there's some complexities with that one. So Lindsay, let me turn to you. And you're still muted. Yeah.
Thanks. So I would love to build on some of the things that were raised by Ambassador Schaefer on the funding and feasibility. One of the things that has been interesting while we've been building the cases of cyber attacks as war crimes is really thinking through what does that trial look like in practice. And it's been very interesting since many of the conversations that have been ongoing since 2007, since the attacks on Estonia, have been very, very theoretical and existed in this academic theoretical debate going on for the last 15 years. So thinking about it in practical terms is really different. And one of the things is looking at how the trial would play out. It would involve a lot of documentary evidence, a lot of expert witness testimony, and there are really some appealing things that would make a trial like this very feasible for somewhere like the ICC Office of the Prosecutor. Obviously, I know one thing that gets raised is cyber attacks do not seem as grave as many of the other crimes that are being committed. But this isn't a suggestion that the Office of the Prosecutor look at cyber crimes instead of those other crimes. It's just facing the reality that it's going to take a very long time to investigate many of the other war crimes that are occurring. Some of those trials are going to be incredibly difficult when you get into issues of proportionality, of legitimate military targets. It's just going to take time. And I really think for investigating some of the cyber attacks that have already occurred, the ICC investigators wouldn't necessarily even need to enter the country. You wouldn't necessarily have a huge victim class, especially if it's charged as attacks on civilian objects, which is how we look at the attacks on critical infrastructure. And there are many experts in this area who have been screaming out, trying to tell the world how vulnerable we are and how big these threats are. So I think would be very motivated to testify to the reports they've written, give expert testimony. So I think that's just an interesting thing, because I think it would be very feasible to have these cases of cyber attacks of war crimes while other investigations are ongoing, and perhaps get some justice against the same perpetrators, some justice for Ukrainians, at the same time having some benefits of providing clarity to the law, which needs clarity. If we just keep discussing it in the theoretical realm, we'll never have that certainty of the law. So actually litigating it in a courtroom would be incredibly valuable for that aspect. So that's some of what we're trying to advocate for, is that this is something that could be a first step. And I keep analogizing it to, getting Al Capone on tax evasion charges, that, this could be one of those cases that gets a first step towards justice while ongoing investigations, very complex and difficult investigations, are ongoing.
Super, thank you, Lindsay. David, could I turn to you next if you want to add anything?
Yes, this has all been just excellent. I would like to amplify what both Ambassador Wenaweser and Professor Hathaway noted regarding what one might look to if we had a separate special tribunal to deal with the war of aggression, the crime of aggression against Russia, while we place the primary investigative task of war crimes, crimes against humanity, and even genocide in the hands of the ICC prosecutor and his team, obviously then working in some coordination with all the other investigative efforts on those three baskets of crimes. But when it comes to the crime of aggression, I do think that the model that was developed in the late 1990s for the Special Court for Sierra Leone is going to be an extremely helpful model. Even certain aspects of the ECCC will also be very helpful to have sort of fertilized that effort, because you are going to be dealing with the Ukrainian government, which, to its credit, is a very strong government and a very determined government. And it will have a lot of opinions. And so in working the negotiations out between the Ukrainian government and the legal counsel's office at the UN and any other governments that want to sort of work in a mediating way between those two entities in order to ultimately have a treaty between the UN as an international institution with international legal personality and the Ukrainian government, you're going to need some mediation as well between, I think, those two parties. And it can be very discreet mediation, but it needs to be mediated well, so that there's a balance, and the ultimate product that comes out of that is not perceived as being, shall we say, sort of Ukrainian biased, but rather one that can stand the test of time under issues of or with an objective point of view and with due process being afforded, et cetera. And frankly, with the integrity of the United Nations standing behind it, because the UN will have to stand behind it. And part of those negotiations, not fully dealing with the Ukrainian government, rather on the UN side, will be how do we sufficiently fund this court up front, because that's a problem we have with the Sierra Leone court. We had to wait a year before we activated it in order to secure 3 years of voluntary funding for it. And that delayed things tremendously in terms of evidence gathering, et cetera, staffing, you name it, while the Civil War was starting to wind down. So that's going to be an important issue to try to work out on funding. And if it is a voluntarily funded court, and you can bet there will be a lot of voices in the General Assembly saying that it must be voluntarily funded, and states with the means must now step forward. Thank you very much. And we'll move on to other priorities. Then there's going to have to be an effort made, with a certain number of OECD countries and others that have the resources to ensure that that voluntary effort is sufficient to cover 2 or 3 years probably. And I'll just close with this. It is possible to imagine that kind of tribunal being built in stages so that you can modify the costing of it in terms of when a full roster of judges have to be on deck and paid. And to make sure that there's no disagreement about that issue, like when are judges actually going to be paid. Let's not debate that 2 years from now. Let's first get the investigative office opened up under a prosecutor, and then take it step by step. But it's a narrow subject, the crime of aggression. It's not as if you have to take on the whole ball of wax with respect to Ukraine. So I think it has a realistic air to it, a realistic character to it, but it has to be very precisely calibrated.
Thank you so much, David. It's important to have those words from someone who's helped negotiate the Sierra Leone Special Court and the Cambodia Tribunal, that you have been there and done this and see that this possibility could be put into place in the instant situation. Ona, would you like to add remarks?
No, I don't have a lot to add, but I guess I have in some ways a question to put to my fellow panelists, because I think a challenge that I see us facing, I think the legal piece of it in some ways are the easy questions. The hard part is, I mean, I think to some degree what Ambassador Schaffer has brought up, is part of the hard part, but also actually getting our hands on defendants. And that strikes me as one of the real challenges. I think Adil's opening comments pointed to the fact that there are already a number of prisoners of war being held in Ukraine who potentially could be subject to war crimes prosecutions. For the crime of aggression, of course, is a leadership crime. And so in order for those trials to move forward, we need people who are higher up to be captured, and at least thus far, as far as I'm aware, that's not happened. And so to the extent that others have comments on kind of what is the way forward in terms of getting those, not just the people on the ground who are engaging in horrific acts and certainly deserve criminal punishment, but those at the leadership level, not just for the crime of aggression, but for the war crimes and crimes against humanity. What is the likely way forward there? I'd be curious. I have my own thoughts, but I'm curious what my fellow panelists have to say about that.
Okay, so let's start with this. Who wants to try to answer? Ona, Ambassador Wenaweser.
Thanks so much. Of course, I mean, it's a key question, and I think the reality is it will certainly take a long time. And as Ona has pointed out, it's a leadership crime. There is, of course, a lot of value in criminal proceedings resulting in indictments and arrest warrants that in and of itself is a bit of a game changer. So we look at it very much that way. And maybe to add, because I passed in a way the first time, by way of general comment, this is a really terrible crisis. We must not forget that, crimes that we're seeing now in Ukraine have been and are being committed in many other parts of the world. So we really want to focus on Ukraine, but we also want to look at this as an opportunity to make long-term gains in the area of accountability. And we do believe, sadly, this crisis moment offers that opportunity, and that's an opportunity we should seize.
I don't know if anyone else wants to weigh in on that one. I can add my own anecdote that a long time ago, I worked for Human Rights Watch, where we had this campaign to arrest Karadzic and Mladic. And at that point, we thought we had no idea if that would ever happen. And then we had this arrest Milosevic campaign and lots of press releases. And at that point also had no idea. Same with Charles Taylor. So, the ICC has indicted 2 heads of state. One of the cases has since collapsed, and the other warrant is out there for genocide. And the individual is now an ex-head of state. So, never say never, but I think Ambassador Sheffer wants to add.
Oh, just to amplify, Ambassador Wenaweser always has pearls of wisdom, so I just get to amplify them, which is how this can help further enhance accountability across the board on a global scale. Let me just give a couple of very small examples from my own country, the United States, just how Ukraine has started to turn the dime a little bit here. It was astonishing that a couple of weeks ago, Senate Resolution 513 was adopted on the floor of the Senate as a sense of Senate resolution, with a large number of conservative Republican senators co-sponsoring it, not just letting it go through, but co-sponsoring it, led by Senator Lindsey Graham of South Carolina. And that resolution actually had very favorable language in it with respect to the ICC. So it was kind of a breakthrough moment as to a recognition of the value of the organization, even by senators who have typically, of course, had very skeptical views of it. The second thing is that, and I just point this out as sort of a heads up, we've been working for a long time in Washington to advance a Crimes Against Humanity bill, led by Chairman Dick Durbin of the Senate Judiciary Committee. And we've been on this very intensively now for quite most of the last year in a very intensive way. And the Ukraine crisis has enabled us to really catapult that forward within the committee. And so no promises, but the point is it allows, if it were to be adopted, which has been our hope ever since 2010, if it were to be adopted here in the United States, it would establish a new foundation of understanding of the ICC, quite frankly, because it would give us the platform to investigate and prosecute crimes against humanity under US federal criminal law for the very first time. And that would, I think, diminish some of the concern about how we in the United States relate to the ICC in the future, and thus be able to support the ICC even more. So just on a micro level, I just wanted to point out, yes, there are reverberations all over the place.
Thank you. Adil, you wanted to add?
Yeah, I'll just put out a thought. So ideally, those responsible for the crime of aggression would not only be brought into custody, put in the dock, convicted, and then punished, imprisoned. That's ideal. If we think that there is value to a conviction in and of itself, an authoritative determination of guilt, we should at least consider trials in absentia. So someone in the Q&A mentioned that the Rome Statute does not allow for trials in absentia. And having just advocated for the ICC as the appropriate forum for an aggression trial, I'm sort of speaking against interest here. But I do think for those who favor a special tribunal, we should at least consider this. We should consider the possibility of a trial in absentia for the crime of aggression if we think there is expressive value in the mere fact of a criminal conviction, even if the individual remains safely ensconced in the Kremlin. If there's something about just convicting those individuals, Vladimir Putin, of aggression, then I think that's something that should be open for discussion.
Interesting thought. There was also a procedure at the Yugoslav tribunal of entering evidence, without having the accused yet, and in the idea that they may never have the accused. And some of the original testimony on the Srebrenica massacre came in that way. And I don't think the Rome Statute has that. So, it's something to ponder. The Special Tribunal for Lebanon is our only tribunal that has allowed in absentia trials. I'm going to combine kind of two questions that were coming up in the Q&A. Sorry, we're not possibly getting to our 36 questions, but I did see issues of US torture and hypocrisy coming up. And, one has to have concerns. US has suddenly discovered the ICC. Well, gee, how does the US come around to the place that this actually also applies to US conduct, and the US shouldn't only endorse the ICC when Russian nationals have committed war crimes? So that question, as well as it also translates to the crime of aggression. So if we look at Justice Jackson's opening statement at Nuremberg, he said the Nuremberg principles would be applied against any nation which disregarded their requirements, including those which sit here now in judgment. Those sitting in judgment were the Soviet Union, France, US, and UK. So how do we, even harder question, getting around to the idea, UK nationals are all out, let's have a Nuremberg style tribunal and prosecute the Russians. But how do we have a broader embrace in both of these respects for multilateralism and the rule of law, not only when Russia breaches it, but when US nationals commit violations as well? Hard question. Who wants to tackle this?
I'll take a very brief hit at it. I mean, you're asking really the very hard questions, and US is, not one necessarily to embrace the limits on itself that it wants to impose on others. And that has been true for a very long time. I guess I see this in much the way that Ambassador Schaefer sees it, which is a promising development in the right direction. The kind of, you see this willingness and interest in engaging with the ICC from people who, not a short time ago were among its fiercest critics and really attacking and try to undermine the institution. We have to remember that it was not long ago the US had sanctions on the ICC, on judges and lawyers who are participating in ICC, on the prosecutor, actual sanctions on them. And attacking the institution as a violation of sovereignty. And so for this turnaround to suddenly realize, oh, actually the ICC can serve a really valuable purpose, and we may want to assist it in its work in this case. And maybe we do want to have some systems of accountability for countries that are willing to violate the most fundamental international legal rights. And I think that what we look for here is baby steps. I think that the idea that the US is suddenly going to embrace the investigation into its actions in Afghanistan and realize that it was, that was a wrong-headed objection, and that, it should subject itself to the jurisdiction of the court. I just don't think that's realistic. But I think what we can do is build understanding that having systems of accountability for violations of the worst international crimes is important to the international community as a whole, and of value to everyone, including the United States. And that's the first step in the right direction.
Terrific. Thank you, Ona. Does anyone else want to weigh in on this one? Okay, then I think I can go to some of the Q&A. I saw one. I have to go find it now. Sorry. Steve writes, the ICC is investigating. Could we opine on the significance of what Russia's withdrawal from the Council of Europe and the European Court of Human Rights, which has issued so many important rulings for victims? Is there a viable realm for the Alien Tort Statute? So I think Adil would be definitely the first part of that question.
Sure. So Ukraine quickly filed an interstate case before the European Court of Human Rights against Russia, and the court very quickly issued interim measures indicating to Russia that it should stop attacks on civilians, on hospitals, on medical facilities, on humanitarian corridors. Stop what you're doing. Obviously, Russia did not do that. One consequence of that has been Russia's removal from the Council of Europe. Obviously, that was not the only reason for that. It's important to note, though, that the court retains jurisdiction over allegations involving Russian conduct for the next 6 months. So Russia is not off the hook for anything it's done in the past or anything it will do in the next 6 months. The court retains jurisdiction over those actions. What does that mean? So first, it means that there is a forum that is expressly designed to center, if you will, the human rights of individual victims. So the crime of aggression is often thought of as a state crime. There's been an effort in recent years to think of it more as a crime, just on a vast scale against individuals, but human rights by their nature are held by individuals. So there's something appealing about having a forum that is expressly designed to center those individuals. What might happen if the court ultimately, and it would take time, issues a judgment against Russia? Having left the Council of Europe already, it's not clear that Russia would have an immediate incentive to comply, not that they've complied with past judgments against them. But if Russia ever wanted to rejoin the Council of Europe, perhaps one condition of reentry could be that they satisfy whatever judgment the court has issued. There's some more interesting sort of legal details about the court's interim measures, but I'll leave that for now since we're short on time.
So I think the Alien Tort Claims Act question raises maybe a broader question of reparations. We haven't really reached this. So we have so much destruction. Victims are going to want compensation and they're going to need to rebuild. You know, we have potential frozen assets of Russian banks. In the US, we have, you know, the potential oil stream. If Russia wants to sell oil in the future, you can imagine, like, could a percentage of revenues, you know, be used to fund this? Anyone have thoughts on these kinds of possibilities for large-scale reparations, both funding, and of course, because of Russia's veto, we won't have any of this created through the Security Council. So again, we need to figure out what kind of follow-up, you know, mechanism could be used to create some kind of claims commission. So in addition to justice, I think there's going to have to be a huge money damages and reparations program. Any thoughts on this? David?
Yes, I think you said the magical words at the very end there, claims commission, which of course we've had experience on with Iran and with Iraq, and we know how to work up a claims commission structure in the aftermath. I would just caution, though, well, not really caution, I would just say that I think we need to keep in mind that we do have some leverage in this respect, in that an unprecedented economic sanctions regime has been imposed upon Russia. I would think that the reparations issue would be very much an issue of negotiation, ultimately, between the government of Russia and other parties to this entire conflict, if not the UN Secretary General or the UN itself, in terms of how to sort this out, because the reparations claims are going to be absolutely enormous, and there will not be much appetite for the West, so to speak, or the non-Russian part of the world to bear the entire cost of rebuilding Ukraine. So all of those frozen assets around the world will be an issue of great concern for negotiators. But I would also say that the lifting of the sanctions stage by stage in the future, that is leverage. And those sanctions, some of them can be held in place until there's a reparations deal negotiated, until there's a claims commission that's actually set up that will operate for many years to come, because it'll take a long time, city by city in Ukraine, to establish the basis for specific reparations claims. And so that will take a long time to unfold, but it will be a matter of negotiation. And I would finally just conclude, going back to Professor Hathaway's point about, how I think she addressed, how are these people going to be actually arrested, et cetera. That's also part of the calculus that can be worked into the economic sanctions. In other words, you can hold back a certain component of those sanctions, not the whole body. I mean, there's too much to be done, but some component of that sanctions could be held back until individuals who have been properly indicted and arrest warrants issued by the ICC or by the special tribunal that might be set up on the war of aggression, until those individuals actually are surrendered. And that could be, years from now when, for example, Putin is no longer in power. It could be many years, but we're used to that. International criminal justice is the long game.
Thank you for those wonderful words of wisdom, David. I think we're out of time, and I have to thank our fantastic panelists. I think hopefully the audience sees the tremendous challenges ahead for the field of accountability. I think there are high expectations, and I think it's important that these expectations are to some extent met, and of course for the victims, because the field ultimately needs to be serving them and not the others. And one must not forget the victims in other situations who maybe are dismayed that Ukraine is drawing so much attention. I think it's appropriate it draws all this attention, but we must not forget the other important situations that the ICC has to deal with. So with that, we're out of time, and I will thank the panelists and the audience. And I apologize, we did not get to the tremendous number of questions. I look forward to reading them, and we'll be in touch with maybe some of the individuals who have sent them in. So thank you so much.
Thank you. Thanks, Jennifer.
Bye.
Good seeing you all.